My name is Ian Alden. I'm happy to be running this workshop today. Before we jump into it, I just want to point out a few available resources for business owners provided by the state and other public entities. It's right here on the first slide. There's a number from the Department of Health, OSHA, and whatnot, just in terms of how you should go about business with regards to health, safety, and whatnot in the age of COVID. There's three main topics that I want to cover here, and it's all part of the same thing. The difference between employees and independent contractors. We're first going to look at the legal definitions of each, because it's very important to understand how you define them and distinguish one from the other. Then we're going to look at some of the immediate practical implications, taxes and insurance being some of the most obvious. But then we're also going to look at some big ones that really spook people, legal and reputational differences. We'll look at some of the important differences and how some of them are a little overblown. But really, we're just going to dive in and make sure that we come out of this workshop with a good understanding of the differences and how you might prioritize hiring one over the other for your particular business needs. So let's start right with the definitions. And we're first going to start with an employee, because that's probably the best place to start, given that an independent contractor is essentially not an employee. There's a number of different definitions for what an employee is, depending on where you're looking and what the context is. I'll give you an example here. The common definition that seems to be applied for unemployment compensation laws, and it kind of spills over into other legal analyses, is provided in New Mexico's unemployment compensation law. I give you the statute here. And there's two key provisions or sections here that we'll look at. But then at the end of this presentation, if we have time, I'm going to actually show you the entire statute. It's long. I mean, there's 11 different definitions, and then section 12 of it is a list of exceptions to the definition. So we'll see how much we can really dive into, but I'm going to highlight the most important ones here. The first is, if you have a contract with an employee saying that they're an employee, basically an employment agreement with someone, they're an employee. You're treating them as an employee, you're defining them as an employee. The law isn't going to look at an employment agreement and say, no, we think they're really an independent contractor. The reverse might be true. The law might say you call them an independent contractor, but they're really an employee. But they won't look at an employment agreement and say, no, we don't think they're really an employee. There's maybe one or two exceptions that are so rare, I don't think they're worth mentioning here. But what happens if you don't have a written employment agreement saying they're an employee? What happens if you're in some gray area where you're not even sure if they're an employee? The big test is found in section 5 of the unemployment law. And number 5 is, it introduces what's traditionally called the ABC test. As you can see, it refers to the 3 different subsections of section 5, which all of them must be true for someone to not be an employee. So, if someone is performing services, if an individual, specifically an individual, not an LLC or partnership or corporation, if an individual is providing services for someone who would be considered an employer, whether that's a business or an individual, sole proprietor, whatever, if you hire someone to provide services for you for wages or other compensation, they are considered an employee by default, unless it's established by a preponderance of the evidence, which is legalese. That basically means greater than 50% likelihood, or more likely than not. They're an employee unless it's more likely than not that A, the individual has been and will continue to be free from control or direction over the performance of the services, both under the individual's contract service and in fact. That last line is very key. And we're going to go over all of these in a little more detail. I'm just introducing you to the test as a whole. B, the service is either outside the usual course of business for which the service is performed, or that such service is performed outside of all the places of business of the enterprise. And C, The individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the contract of service. So those are the three parts of the ABC test. Before we cover that in more detail, what is an independent contractor? Like I said, they're basically not an employee. It's someone who's engaged to provide specific services. Common examples of independent contractors: you hire an electrician to do some work, or a plumber, or another service provider engaged in whatever business. So those are classic examples, because they're tradespeople who are engaged in their own business, and they'd be in that business regardless of whether or not they're providing services for you. The relationship can't fit the legal definition of employment, because if so, then they're not an independent contractor, with a weird exception for statutory employees, which we'll talk about in a little bit. But they're one or the other functionally. Let's look at the ABC test, because this is really the meat and bones of the analysis of whether or not someone is an independent contractor or not. And you see this, some variation of this test in most states. In fact, you might have heard the back and forth over the last few years in California having to do with ride sharing services like Uber and Lyft. California has a slightly modified standard, but it's functionally an ABC test. And they found that, the ride sharing people, the independent contractors, were really employees, and Uber and Lyft had to circumvent the test by writing a new law and then getting the voters to adopt it, specifically exempting ride sharing people from this analysis. So it can have some interesting ramifications. But looking at the first test, A, and this is, in my opinion, the most subjective. The individual has been and will continue to be free from control or direction over the performance of the services, both under the individual's contract of service and in fact. You notice the first point I make here: it's not enough that you simply say in some written agreement with them that they're an independent contractor and that you're not going to have control over them, but then in fact, you're directing them and micromanaging them. If it's a very subjective test, and they're going to look not only at what's in writing, but what you actually do with these people. So some common examples here is controlling schedule, or controlling where people work or how they work. If you have a protocol guide where people who are independent contractors have to show up during these hours, or follow a sales script, or things like that. That's the sort of control that the state or a court is going to look at and say, you were directing their performance to such a degree that you can't call them independent. Therefore, they're not an independent contractor. So the first test is very, very subjective and fact-based, and every one situation is ultimately going to be different. But, there's some guiding lines here. Don't, like I said, don't micromanage, whether in writing or in actuality. If they're going to be your independent contractor, you have to trust them to do the job you're retaining them to do without excess control by you. The second test is a really interesting one, I think. The services that these folks are providing are either going to be outside your usual course of business, or performed outside of all your places of business. And I'll give you some examples here. For one thing, you can't have independent contractors working the cash register at your store. I've had a lot of clients ask me this question specifically. You can't, for a number of reasons. One, because it obviously fails test A. You're going to be controlling the cash handling procedures to a great extent. You just are. You don't want to trust independent contractors to come up with their own protocols for how to handle your money. But it also fails test B, because they're going to be providing that service in only one location, which is your place of business, which, notice test B contains two parts, and it's an either or situation. If the independent contractor is only providing their services at your principal place of business, which, for example, your store, if they're only providing it at your store, it fails the test. So another example, big box retailers, You can't have a sales staff that works in your building comprised of independent contractors. You just can't because they're only providing their sales services on your behalf in your principal place of business. So it fails the second test. Some people try and get around this by having independent contractors that are engaged by specific vendors. And I'll give you an example. Best Buy does this. You go there and you see Microsoft salespeople, Samsung salespeople, but those folks are engaged directly by, for example, Microsoft or Samsung as part of some contract with Best Buy. So they may be independent contractors, but they're not working directly for that retailer. The third test, and this is one that I find academically the most interesting, and we're going to go over some of the case law, and I'll explain why I disagree profoundly with the case law. But the third test is that the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the contract of service. And, again, go back to the classic examples, electricians, plumbers, and tradespeople. They're going to be providing those services to a number of clients or customers, not just you. And they're doing that independently of whatever you're engaging them for. So whether you engage them or not, they're going to be doing that business. But salespeople is a very interesting example because you think about door-to-door salespeople, or in the modern age, online salespeople, or cold calling salespeople, for example. Are they engaged in the business of selling your company's products, or just some other examples of independent contractors? I've seen this be the case with doctors, medical doctors working for a medical facility. They'll be independent contractors of a hospital, for example. And the argument goes, well, they're running their own practice within the hospital, but they're running their own business. And so test C, I guess it's also pretty subjective, but there's a good amount of case law on it because, the state, for example, the Unemployment Commission, a lot of people take issue with the notion that some of these folks are, in fact, in their own independent business. But let's look at some case law to shed some light on this. Probably the seminal case here, it's Solar Age Manufacturing versus the Employment Security Department in New Mexico. It's a 1986 Supreme Court of New Mexico decision that's still valid law today. The state of New Mexico looked at salespeople of this solar company that they were selling solar power collectors, some door to door, some at trade shows. And the state said, well, look, they're not in an independent business because if they're selling solar power collectors for you, but they wouldn't be selling those for other businesses, presumably. They're doing this just because you specifically engaged them for it. They wouldn't be solar power collector salespeople otherwise. The court looked at this and disagreed with the state's assertion and held that these salespeople were, in fact, independent contractors. So you look at the ABC test here. Test A, the solar company didn't exercise control over the means of sales or even the sales price, which is very important here. The court focused extensively on this. The salespeople worked whatever hours they wanted to work, sold wherever they wanted to sell. Their location of sale wasn't dictated by the company. They went to trade shows, they went door to door, maybe some of them cold called out of the phone book. Again, 1986. If, the salesperson determined the price of what they sold, they were compensated by the company for any, sales price above the wholesale price. But if they sold for less than the wholesale price, that was their right, but the salespeople had to pay the company the difference. Basically, the salesperson paid the company the wholesale price and they kept the difference. So there was no real control exercised, except, the ultimate decision of whether to retain or terminate an independent contractor. Oh yeah, they also didn't provide scripts or anything like that. There wasn't a sales script where you cold called out of the phone book and had to read, "Hi, my name is so-and-so. I'm selling on behalf of this company. Would you be interested in this product? Let me tell you about it." There was no script here. Look at test B. The sales didn't occur at the solar company's place of business. In fact, they occurred pretty much everywhere but their place of business. So test B was satisfied because it's an either or test. Test C, this is really what the lawsuit was about, was whether these salespeople were engaged in an independently established trade. And the question becomes, again, would this person be engaged in the independently established trade, but for your engagement of them? And the court looked at salespeople specifically and said, we think yes, because door to door salespeople are probably selling a number of products. And here's the actual text of the case here. But they said, they're selling a number of products, presumably at the same time as this. They're engaged in the business of sales. That's their livelihood. If they weren't selling solar products, they'd be selling something else. And so, even if they wouldn't be selling solar products, but for your engagement, the fact that they are salespeople by trade means that you can engage them as independent contractors to sell your products without treating them as employees. And so the court essentially narrowed the focus of part C of the ABC test, not to whether, someone is engaged in such a unique trade that they would be providing services like they are to you, but more so just, are they engaged in the trade generally, such that they could provide services to you under that trade? And there's a little bit of language here that I'm latching onto, and we'll go over in a second. Salespersons need little more than an automobile and a pen to carry on their tangible trade. They have a proprietary interest in their skills, meaning they have an interest unique to them, regardless of what their, independent contractor, the company or enterprise wants. They may be temporarily unemployed if not selling their products for the particular enterprise, but that's not determinative here. And the court looks at other tradespeople, lawyers, doctors as well, which is why you can expand this out a little bit and treat doctors as independent contractors for kind of the same reason. Yeah. So, you just look at the fact that if these people wouldn't be providing their services to your particular enterprise, they'd be providing them to some other enterprise or independently. So that is how the ABC test is interpreted here in the state of New Mexico. So we look at, does the rationale apply today? And I would say maybe yes to some degree, but also arguably no. Looking at the rationale of 1986, it's somewhat outdated, in my opinion, because you look at what the court said about these salespeople need only a pen and a pencil and some paper and their own car to engage in their trade. It's really not true anymore in the 21st century, especially when you look at digital marketing and integrative advertising and marketing solutions that are very company driven. Salespeople arguably are under greater control today by the people and companies that engage them, and they probably would not be engaged in the sales trade for any particular enterprise or product if not engaged directly by them. You don't see salespeople selling multiple products anymore. You see maybe search engine optimization folks who are helping businesses from different industries market their own products, but really you don't see door-to-door salespeople selling multiple products from multiple companies, sellers, vendors, manufacturers. It's kind of some outmoded thinking. So if this case were challenged today, would it hold up? Maybe yes, maybe no, but I think we are going to see some evolution in this area in the next few years, particularly with, like I mentioned earlier, the ride sharing folks, Uber and Lyft employees, for example, and the evolution of independent contractor law in the wake of the gig economy. I think we're going to see some evolution here, but that right there is the basic test that still applies today, the ABC test. We're going to look at statutory employees. Some of you may have heard of this. They're basically independent contractors who, for legal purposes, are independent contractors still, but for purposes of tax withholding, they're considered employees under the law. And that means that you might treat them as an independent contractor. You're not controlling them. They might not be covered by your insurance, as we'll touch on later. But legally, you're required to withhold taxes from the money you pay them and remit that money to the tax authorities, specifically the IRS and probably the state to some degree. Um, Statutory employees, there's only four categories of them. So it's not like this is something you really need to worry about. But here's the four. Um, a driver who distributes beverages other than milk or meat, vegetable, fruit, or bakery products, or who picks up and delivers laundry or dry cleaning if the driver is your agent or is paid on commission. This is going to be really important because of the changes to the law that just passed a few days ago that allows alcohol delivery services. Depending on how you pay your employees or slash independent contractors, if you're in that field of, beverage delivery or produce delivery, you might be looking at statutory employees if you're otherwise treating them as independent contractors. If you treat your delivery folk as regular employees, there's no problem here. They're just employees. But if you treat them as independent contractors, you're probably going to have to, withhold taxes from their compensation and pay them to the IRS. Life insurance sales agents, if they're captive, if they're selling for one carrier or company, if you're treating them as an independent contractor and you're paying them, they're probably statutory employees. If you've got someone who's a work at home independent contractor based on stuff you furnish or supply them and that have to be returned to you, and you're providing them specs, they're probably a statutory employee. Think, at-home carpenters, maybe. I mean, it's an odd category. Salespeople, traveling salespeople. We always turn back to these examples. These folks may be statutory employees, depending on how you're paying them and the specific work that they're doing. There's a three-part test to see if you actually need to withhold taxes from these statutory employees' compensation. If you have a service contract that states they're the ones who have to be providing the services directly, like they can't farm it out to their own employees. If they don't have a substantial investment in what they're using to provide the services, and if they're providing the services on a continuing basis for the same payer or enterprise. So that's statutory employees in a nutshell. I'm not spending too much time on it because it's a very niche area of employment law. Most folks don't deal with them. If you think you might have statutory employees, I definitely encourage you to reach out to your accountant, CPA, or a good tax lawyer. If you're not sure where to start there, reach out to the SBTC, set up a counseling session with them. They are very good at walking you through some of these analyses to the extent they can. If they can't because it's just outside their scope, they will refer you to folks who can help you.
We have one that's asking about what about therapists?
So therapists, depending, I've actually worked with practices in the past that have considered their therapists as independent contractors, and on paper they passed the ABC test, except it turns out they really didn't when they hired us as they hired me specifically as an attorney to look at it. The problem with them was Part C, where those therapists conduct their business. Because what they did, they had a practice, they had a building here in Albuquerque. They hired a bunch of independent contractors and said, we're not going to control your hours, we're not going to control your how you do your job. We're not going to hold you to specific standards unless you do something profound to embarrass us as a practice. Were the therapists were engaged in the practice of therapy, if not at this practice, then generally on their own or for another would-be employer. So they passed A and C, but they failed B because they had to provide the services at the building of the overall practice. So they failed Section B, and the state actually assessed them for back due unemployment contributions. There was, of course, the workers' comp issues. And then the big issue for them was one of their therapists made a claim against them for failure to withhold and pay taxes. That's where a lot of these claims come from, is when an independent contractor doesn't realize that they have to pay their own taxes, or maybe you've pointed it out to them and they just don't. And they say, oh no. And then they point the finger at you and say, you should have done that. I was really an employee. Why didn't you withhold my taxes? That's where a lot of these claims end up coming from, in all honesty. So I would say, with regard to therapists, if you're having them work at a central place of business, which is your practice, they probably fail subsection B, in that they're providing the services only at your place of business. And put an asterisk in that, because you see medical doctors in hospitals who they provide their medical service within the hospital, and they're considered their own practitioners, their own business owners. The reason for that is because those doctors typically have their own business entities. They're not engaged necessarily as individuals by the hospitals. The hospitals will engage such and such partnership and lease office space to them within the hospitals for their practice. They'll they'll engage them to provide those services through the entity. So that is one way around this ABC test, because if you're engaging a business entity, an LLC, that's not a disregarded entity, a corporation, a partnership, that's different. They fundamentally can't be employees at that point.
And it's on the same topic. I asked the other question. So now that we're doing telehealth, am I understanding correctly that it'd be okay that they continue to do the work from their home, but just not at, like, if I had a building or a business, unless I was like subleasing to them?
It depends really on how you ultimately structure this in your agreement with them. I would say that if they're doing it via telehealth, you're no longer controlling where they do the business, where they do their business. They're not exclusively or even necessarily at all providing the services in your building, but they don't see outside clients. If they're going to provide services in your building at all, either now or once the pandemic ends, I'd say they still probably fail test B if you're engaging them directly to provide these services. Like if you were providing, for example, therapy practice LLC or therapy practice PC, professional corporation, and you are engaging these therapists as individuals to provide their therapy services. The bottom line is, if you're engaging them as individuals and they're going to eventually come back to provide services in your building, providing services at all in your practice building will cause them to fail Section B, because it's not a question of if they only provide services there. It's a question of if they provide services there at all. So I would say they'll probably still fail. Now that said, depending on how you structure your own practice, if it's like a group of practices where you're contracting with these therapists who run their own practices, like I said, therapist A LLC, to provide their services as a subset of your own group practice, then maybe you can get around that test, test B, because then they can't be employees. They could only be independent contractors, essentially. I guess my recommendation here would be work with someone, like I said, good CPA, or you're probably going to want to jump right to a good attorney who deals with employment law, or reach out to the SBDC to structure your deal with these therapists in such a way that you are threading the needle. Because I think there's a way to do this for you, but it's complicated. So why does it matter whether someone's an employee or an independent contractor? Well, I talked about the withholding taxes already. That's one of the big things, and that's where a lot of these claims come from, is you don't withhold taxes from the payments you make to these folks, and then they don't realize that as an independent contractor they have to do it themselves, so they fail to do it, and then they point the finger and blame you. There's the obvious taxes. There's federal income, state income, Social Security, Medicare, workers' comp taxes that you have to withhold. But one of the biggest things, and I didn't mention it in this slide, but one of the biggest things that creates these conflicts is gross receipts tax. As an employee, there's no gross receipts tax for these folks. They're receiving wages, but as independent contractors, they're considered service providers by the state of New Mexico, and they're required to pay gross receipts tax on the value of what they're receiving from you, regardless of whether or not they pass on those taxes to you in the form of a surcharge, a 7.875% surcharge or whatever. So they will go to the state and argue that they were misclassified employees, because if the state agrees with them, then they reclassify their income as employment income. You, as the employer, get hit with a number of taxes, fees, and penalties, but they no longer owe that 8% gross receipts tax on the money they received in prior years. So that's another reason why a lot of these conflicts arise and why they have real value for misclassified employees. So it's important to make sure that you're not misclassifying them. There's workers' comp insurance. If you employ 3 or more workers, including owners and family members, they all count towards that minimum of 3. You have to pay into federal and state unemployment insurance schemes. New Mexico obviously has its own, which your rates vary depending on the number of employees, number of claims. There's kind of a risk calculation that goes into your unemployment rates. So matters for that. If they are considered employees and you fire them, they can claim unemployment. So that matters for you, because if they claim unemployment, it raises your rates potentially. Both federal and state governments have a vested interest in proper employee classification. This isn't just a state thing. The IRS has its own standard here. I'd encourage you all to, on your own time, come back to this slide. You can get a copy of the slide deck from the SBDC. Go back to this slide and actually look at some of these links here, because they kind of explain your employer obligations and might give you an even better sense of why it's really important not to misclassify these folks, because you could be looking at penalties both from the federal and state governments. Insurance is a big thing. Most businesses carry commercial liability insurance. Some businesses cover professional liability or errors and omissions policies. Service providers, people with malpractice risk, it's a form of professional liability insurance. Doctors, lawyers, accountants, by and large, will have E&O or professional liability policies to cover their professional negligence or malpractice. These policies are by and large written to cover the businesses and their principals and employees. They are almost, I'm not saying always, but very commonly written to specifically exclude independent contractors unless they are specifically named as insureds or additional insureds. So when you hire independent contractors, they might not be covered by your insurance policies, which could be a good thing or could be a bad thing depending on your perspective, because in a claim against you and an independent contractor, obviously you want insurance to be able to cover a claim in any event to the extent it creates liability for you. And it may not when it comes to independent contractors. And we're going to look at an example of how liability could be split a little bit later here. But, insurance considerations are important. It really depends on the policy. So one of the best things you can do if you just want to be absolutely safe and maybe pay a little more for your premiums, but be safe, is make sure your policy is specifically written to include independent contractors. Maybe you pay a little more. Maybe those policies give the insurance company a right of subrogation or a right to go after the independent contractor, or their insurance policies, the independent contractor's insurance policies, to recover. Maybe they say the independent contractor's insurance policies will pay first, but these things matter. So if there's one big takeaway from this, and there should be several, but one of them should be go look at your own insurance policies and make sure they're covering your employees, and if you want them to, your independent contractors. But When you have an independent contractor, you typically have a written agreement with them that hires them to provide the services that they're going to provide. That agreement should require, in part, that they procure their own insurance policies to cover the services they're providing, whether that's commercial liability, errors and omissions, professional liability, you name it. Make sure that they have their own insurance coverage. The agreements also usually require, or good ones do, that they name you as, your business as an additional insured, and that the independent contractor provide you with proof that this policy exists and is in good force. And that usually means at the offset of the agreement. And occasionally when you demand it, it's good to check up and make sure that they have kept the coverage up. Because if the independent contractor lets the coverage lapse, oh, well, so sad. I've seen this happen repeatedly with independent contractors. So make sure that they're getting their own insurance and keeping it up. You should also make sure that they have indemnification agreements, that the independent contractors indemnify you in the event that they do something bad or they don't do something that they're supposed to do. It's important to have these written agreements in place to cover you. But insurance, it's a really big thing that a lot of people overlook when they're dealing with independent contractors. And when the claim comes, it can really bite you. I've got another question about the therapy office about gross receipts tax. If you pay gross receipts tax, does that mean classifying as an independent contractor is wrong? It really depends on what you're paying the gross receipts tax for. And here's an example. Gross receipts tax, you could almost think of it as a value added tax in that things can be taxed multiple times along the chain. So, for example, if you run a business and you sell services to a customer, like your business's services, you're going to package a product, some services and whatnot, and you sell to your customer, you're going to charge your customer the tax for those services typically. And then let's say you go out and hire an independent contractor to provide those services. They're therapists, for example. You're hiring them as therapists to provide the services that you just charge your customer for. The therapist is providing a separate service to or on behalf of your practice. And so they're going to have their own gross receipts tax obligation. So the money being paid by the patient or client, or however you classify them, is getting taxed twice in a sense. Your practice is paying gross receipts tax on it, and then the therapist is paying gross receipts tax on their services that they're providing on your behalf to those clients. And there's some exceptions to this, reseller exceptions. There's some specific carve-outs for medical service providers. I suggest talking to your CPA or a tax attorney to get a sense of your gross receipts tax obligations as well as that of your therapists, especially if you're treating them as independent contractors. Again, if they're employees, what you're paying them is wages, and that's not subject to gross receipts tax. Yeah, I mean, you could be looking at a double tax situation, or maybe there's a deduction or exemption that applies for you, but it's very possible that the therapist is, they're paying their own gross receipts tax even after the practice pays its. Legal responsibility, employees versus independent contractors. There's this thing called vicarious liability, which is that if you are an employer, you are employing these people, your employees to provide services for you or whatever it is they're going to do. You are, as the employer, responsible for employee negligence, which is a specific tort. If your employee, I'll give you a common example. Your employee mops the floor, doesn't put out wet floor signs, and someone walks into your store and slips and falls. That's a traditional example of employee negligence that an employer would be responsible for under the theory of vicarious liability, or if you prefer the Latin term, which no one does, but I threw it in here anyway because I'm a lawyer and I have to, respondeat superior, which is an employer is responsible for the harms caused by their employees, specifically if the employee negligence occurs within the course and scope of employment. If an employee, they work for you for 8 hours, they get off at 5, they go to a bar, it's 8:30, they're drunk, they drive home and get into a car accident, has nothing to do with their employment, presumably. If they're a traveling employee, they're traveling for work, that becomes a weird gray area that a lot of case law focuses on. But just generally speaking, if it's not within the course and scope of their employment, you're not liable for it as the employer. Acts wholly unrelated to the purpose of employment are typically outside of scope. So if, for example, the employee, you've got an employee, they go into the break room and they light up a cigarette, in clear violation of your policies, and they put the cigarette down on the table or the couch or something, and it starts a fire that destroys someone else's property or you know something. It's outside, what they did is outside the scope of their employment. Theoretically, maybe it is, maybe it isn't. It's a very subjective test. Maybe a more common example, and this isn't really negligence, but it's clearly outside the scope. If your employee assaults someone, like physically assaults someone over a personal disagreement that they're having on your sales floor, that's presumably outside the course of employment. Keep in mind that despite these legal analyses, there's all kinds of legal gray areas here where people try and get around this by saying, oh, it's tangentially related to the scope of employment. So, vicarious liability is a real thing and employers bear the brunt of it. It's one of the reasons why your insurance needs to cover your employees and their negligence at a minimum. I'm a firm believer in expansive insurance policies. The more it covers, the better. But businesses are typically not vicariously liable for the negligence of independent contractors, which is one of the big advantages to engaging them. Independent contractors are their own separate business owners in theory with their own capacity to be held liable, and they should have their own insurance. Again, make sure you're requiring it of them and getting proof that they have it. But that doesn't necessarily get you out of liabilities created by their work on your premises. For example, if you hire an independent contractor to fix or install a light fixture, and that light fixture is in your business hovering over your sales floor, and they did a bad job and it falls down and hits someone on the head, you are not necessarily going to escape liability for that by virtue of having hired an independent contractor, because you still owe a duty of care to the people who are in your building. And so we'll look at a case recently here in New Mexico. This isn't 1986. Safeway Inc. versus Reuter. Reuter was an independent contractor hired to install a baby changing station in a Safeway store. They did a bad job. It fell down, injured someone, I think maybe the baby. They sued. The jury said, we think Safeway and Reuter, the independent contractor, are both at fault here, 40%, 60%. And this created some very interesting implications because when a jury uses what's called comparative fault here in New Mexico, there is, 40%, 60%. That's the jury saying, despite whatever agreement you have with your independent contractor, you, the enterprise, are 40% at fault here. So you have to pay 40% of the damages. It negated Safeway's right to go after Reuter under the indemnification language in the contract with Reuter that said Reuter has to pay for any damages that are assessed against Safeway. That's a very common provision in independent contractor agreements. But once the court finds that you, the enterprise, are responsible, the independent contractor is off the hook. And so that's why you need your own insurance even if you're using independent contractors, and why B, using independent contractors doesn't always get you out of liability. There are still these situations where you're responsible for what they do in your building if you owe a separate duty of care to people. Another example of why independent contractors don't always get you out of liability, if you're using them to let's say you're selling solar systems to homeowners and you use independent contractors to handle the sales, handle the install, the delivery and install of the equipment, but the contract is between the customers and your company. And the contract says your company, no matter how it happens, whether independent contractors or otherwise, your company is going to sell, install, and maintain this equipment. And then your independent contractors do a bad job, or they don't do the job at all, whatever the case may be. you're still responsible under breach of contract because you had a contract with the customer. It doesn't matter how you get the job done, but the responsibility ultimately falls on you and your company to make sure that the contract you signed is honored. So independent contractors don't get you out of breach of contract responsibility. You might be able to sue the independent contractor for indemnification or something, but you're still ultimately the one who has to deal with that. Again, case law is always evolving with regard to independent contractors, especially in the age of the gig economy. We're seeing these cases recently come out in other states where businesses are being sued and held liable just because they didn't vet the independent contractors well. We've had a negligent hiring, retention, and supervision claim in New Mexico for years as far as employees go. If you hire an employee with a bad criminal record who then commits that same crime against one of your customers, that's negligent hiring or retention or supervision or some combination of the above. But that traditionally hasn't been used against independent contractors until recently. I think Wisconsin just had a case in the last 5 years that allowed it. I can easily see New Mexico with a fairly liberal judiciary allowing these sorts of claims to move forward in the future. So keep that in mind, is you should certainly vet your independent contractors before you hire them. Lastly, reputational fallout is a big thing. If your employee performs badly, makes you look bad, your brand suffers. Same of an independent contractor, but getting rid of them looks different. You can always fire an employee, assuming that they're not hired for a term of employment. If you have a written agreement that says you are my employee for 1 year, come hell or high water, um, that right there, you might not be able to fire them, or maybe you can, but the contract provides some consequence, like you have to pay them their full salary. Who knows? But otherwise, you can always fire them. New Mexico is an at-will state, but you might be looking at wrongful termination claims or lawsuits. You could be looking at unemployment insurance claims that'll potentially drive up your rates. Wrongful termination claims, if they're alleging you discriminated against them based on their race, sex, age, you name it. I mean, and if they're in any protected class, it can create headaches. So obviously you need to make sure that you're keeping these things in your mind as you deal with hiring and firing decisions. Have a good HR rep or outsource HR functions to a firm or person who does HR maybe, but keep these things in mind. For independent contractors, the process is a little different. You can typically always terminate an independent contractor unless, again, the agreement is for a specific term and you don't have a right to terminate. If you terminate an independent contractor without the right, you're looking at a breach of contract claim. Similarly, there's indemnification obligations that might have to be enforced even after you terminate them. There could be reciprocal or unilateral duties to defend. So it can get complicated. And I'm not saying employees or independent contractors are better in this regard. They're just different. So be aware that it's not simple for either classification. The last thing I'm going to touch on really quick here, references, employee references. New Mexico actually has a safe harbor law. If your employee wants to go work for someone else and the prospective employer calls you looking for a reference, we have a safe harbor law, and I've copied and pasted it here so you can see it, that provides you a safe harbor if you are honestly speaking to the former employee's job performance. Doesn't cover you if you are, knowingly false or deliberately misleading, or if you're giving the reference with malicious purpose, which is very subjective, and who knows what that means ultimately, or if you violate any civil rights of the former employee by giving the reference. But otherwise, it's a legal safe harbor. Someone calls you for a reference, you can give an honest one within these confines. It's not true for independent contractors because they're not employees under the law. So if an independent contractor uses you as a reference, you have to be careful that you're not drawing a defamation claim. If you don't have something nice to say about them, you might just want to say nothing and decline to give the reference as far as independent contractors go. So again, every business owner's needs and priorities and situations are very different to them. It's very important to have a good hiring strategy. Don't just hire as the need arises necessarily, but really sit down and think about short, mid, and long term what your needs are going to be, and come up with a good hiring strategy that includes HR policies and procedures, and looks at whether or not these people you might want to be independent contractors are being misclassified. I've got one question. I'm considering an employee. Our office is attached to a garage at our home. What are the obligations, liabilities? Also, can that person use our bathroom inside the house? Great question. I'm going to suggest that you really want to tread carefully here, because your home is covered by typically either a homeowner's policy or a renter's policy, depending on if you own the home or not. These insurance policies cover the use of the premises almost exclusively, typically exclusively, for residential purposes. If you're running a business out of the home, it's typically fine as long as you're the only people in the home and you're not running the risk of harming a third party on the premises. But if you bring an employee on to your home business, your homeowner's policy, which covers the premises liability, is probably not going to cover any injury to them. You'd want to check the policy. So that's my first word of caution right there is you might need to get overlapping coverage to cover your use of the house for business purposes. Those are potential liabilities right then and there, because if someone is injured in your home, there's claims that are going to be made. Your home is also opened up to potential liability, even if you're operating your business as an LLC. Because your home is owned by you personally, you could be drawn into any lawsuit which would waive or potentially waive your owner protections as owners of the limited liability company. For example, if your business was an LLC but you're using your personal home, it puts your home at risk at a minimum in the event of any claims against you, whether by that employee or by third parties. Fun fact. And it could, create personal liability for you as the owners, even beyond your home. So it's kind of deviating from the employee versus independent contractor thing, but a lot of risks there. I'd recommend talking to an attorney about it to see how you can mitigate those risks as much as possible. An attorney and maybe an insurance broker. The independent contractor distinction doesn't matter as much, in my opinion, there. I mean, there's the classic considerations, taxes, liabilities, etc. But, employer independent contractor, the risks to you and your property are pretty extensive. Again, this is kind of like drinking from a fire hose, and I definitely get that. The analysis at the end of the day is very subjective. It matters almost as much who you get performing the analysis as it does your specific fact pattern, because two state employees might look at the facts and come to very different conclusions. That happens a lot in tax law, and it happens a lot with employment law. So keep that in mind. And also keep in mind that some big takeaways here are, if you're going to use independent contractors, make sure they're really independent contractors. When in doubt, speak to a good HR person, speak to an employment law attorney. Do your due diligence now, because these claims can be filed retroactively for misclassified employees, and you could be looking at years worth of penalties and consequences.